Thank you for selecting Mediation Mastery, Navigating Through the Personal Injury Case. I'm Edward Montoya, and I'll discuss some critical topics to help you navigate through a personal injury mediation. The suggestions, strategies, and techniques can be applied whether your mediation is live or on video, such as Zoom or WebEx. I will help you fine-tune your mediation presentation and negotiation strategies in order to close the deal at the mediation table. The hope is to give you insight into how to better prepare for mediation and develop sound negotiation skills. I've been practicing law for over 30 years, and over that time, I've questioned at times why some cases settle at mediation and others don't. I began to think that perhaps I was doing something wrong. I felt I didn't have a consistent negotiation framework, and I felt a bit frustrated. And it wasn't until I completed my master's in negotiation and conflict resolution and became a certified mediator that I realized that there was so much more to mediations and negotiations than meets the eye. I'd like to share some quick points about mediation. Mediation is a confidential process guided by a third-party neutral. The objective is to help the parties resolve their dispute while they control the process. Mediation is cost-effective and can offer a timely solution to complicated matters. For some people, advocating and negotiating for clients may be second nature. For others, negotiations take a lot of time and preparation, and I think I fall into that category. But no matter your experience level, preparation of your case and yourself is essential. In my view, an effective negotiator is someone who's aware of their biases, can separate their emotions from the case, is empathetic, creative, and a person who really cares about their client's needs and interests. It is someone who listens, asks questions, can reframe statements with a positive vibe, and is respectful toward others. This person builds trust with others because of their transparency and their win-win attitude. These negotiation geniuses have an open mindset, are patient, and take a collaborative approach toward everything they do. Mediation is mandatory in all state-filed cases in Florida, from small claims court to family to civil matters such as personal injury, wrongful death, and premise liability cases, to name a few. Florida Rule 1.700, 1.710, and 1.720 will help you manage a mediation as a party. Rule 1.70 spells out who selects a mediator. It states that a mediator can be stipulated by the parties or referred by a presiding judge. The way the mediator selection process works in personal injury cases and other actions is that each party offers the names of a potential mediator or set of mediators to the other side. The parties will either agree on a mediator or they could ask the court to select one for them. Rule 1.710 states that the mediation needs to be completed within 45 days of the first conference. But understand that the parties can extend this time if there's ongoing negotiations. Rule 1.720 explains the mediation procedure and spells out who needs to appear at mediation. Under this rule, it is critical to have the right parties at the table and those with full authority to settle the case for an amount up to the plaintiff's last demand or the policy limits. Just as an example, if your personal injury case is a policy limits case of, let's say, $500,000, it may benefit you not to negotiate before mediation, because by doing so, you may give way to having an adjuster with less authority than policy limits. Think about that while in the pre-suit stage of other cases and ask yourself, if I ask for policy limits in my demand letter, but then negotiate for less than the limits, will the person at the mediation table have full authority for the policy limits, or will they simply have authority for my last demand? I believe the latter will hold true. Rule 1.270 speaks to the term full authority, which has been a point of contention. Here, the rule defines full authority as the final decision maker to all issues presented by the case, who has legal authority to execute a binding settlement agreement on behalf of the party. This could be an adjuster on a case, his or her supervisor, or anyone with the power, including opposing counsel if the adjuster gives him or her that power. In plaintiff cases, this could be the claimant herself, her spouse, her kids, or anyone who may have a claim within the case. Under 1.720E, unless stipulated by the parties, each party must file a certification of authority at least 10 days before the mediation. The filing will identify the person or persons who will appear at the conference as a party representative or as an insurance carrier representative. As mentioned before, in a plaintiff case, it could be the spouse or people having claims within the case. If you're stipulating to the parties that will appear, confirm in writing who will appear and what authority they will have. So call the other side and clarify this point if it's not clear. Make sure to get some kind of written communication, whether it's an email or a formal letter, that can be attached to a motion for sanctions if the other side fails to meet its obligation or commitment. My advice is to pay special attention to this issue because parties are notorious for not having people with the right authority at the table. For example, in a wrongful death case or severe injury matter that exceeds the policy limits of $1 million, where plaintiffs have alleged bad faith and have demanded $10 million, it's quite possible that the defense might send someone with authority to resolve the case up to $1 million. Folks, this happens, so keep an eye out. In this slide, I provide sample language for a certificate of authority. It is important to cite Rule 1.720E. Advise the parties who will appear at mediation and what authority they will have. Here, Jack Smith will have full authority to settle up to the amount of the plaintiff's last demand or ABC's policy limits, whichever is less, without further authority or consultation. Under 1.20F, you could also be sanctioned if you don't show up to mediation or fail to have the party with full authority at the mediation table, unless you have good cause. However, sanctionable conduct includes failing to file the required confirmation of authority notice under 1.720E, or not having the persons identified in the confirmation notice at the mediation table, among many other things. Be careful because these two issues create a rebuttable presumption of a failure to appear. The failing party may be subject to paying the mediator's fees as well as attorney's fees and costs. Preparing for mediation. The mediation process is straightforward and follows a natural progression. Submitting pre-mediation statements helps the mediator understand the case, the parties' needs, and their positions. The mediator's opening helps guide the tone of the conversation, and each party's presentation should give the mediator and opposing counsel context regarding their client's needs and wants. I also recommend reiterating at the mediation opening that you are there with an open mindset to find a solution to the case. As you may know, there are joint sessions and caucuses in mediation. I find these elements to be very helpful in personal injury cases because they allow parties to transform their mindsets from a distributive or adversarial perspective to one that's integrative and collaborative. It is important to prepare clients for mediation. Some strategies include communicating with clients before mediation, whether via Zoom, over the telephone, or bringing them in person. And I find that particularly useful in personal injury cases involving severe and debilitating injuries, such as head trauma or paralysis. In those cases, victims can be extra sensitive to emotions and may become frustrated easily. Another issue that comes up a lot at mediation are client expectations. Keep in mind that clients converse with friends, other lawyers, and other people in the community. And in many cases, clients walk into mediation expecting similar results to their friend's case. Having them see the issues and problems in a case can be difficult. For that reason, communicating with your client before mediation is essential to lower and ground their expectations and shift their mindset to consider realistic figures. Mediators realize this and are there to help you without passing judgment. I recommend you share this potential issue with them as well. Now, if you run across these issues at mediation, ask for a break and meet with your client. Discuss these issues, reframe, and come back to the mediation table with a fresh perspective. It's always a good idea to be prepared to tackle issues on the merits of your case and the emotional aspects associated with counter arguments, counter offers, and power plays. After all, we're all human, and so we're subject to those emotions. So pay attention to yourself, how you behave at mediation, and be self-aware and remind yourself of your values, your ethics, and your belief system. I recommend that you think about anything that could cause potential bias or feelings toward opposing counsel, the mediator, or even your client. Do this several days before mediation by thinking of how you will handle the mediation if these issues occur. Ask yourself, has opposing counsel done anything or said anything during the pendency of this case that would make me upset at mediation? What happened? What can I do differently? Develop strategies to set aside those feelings. However, despite your feelings, actively listen to opposing counsel's arguments, your client's needs, and what the mediator is suggesting. Don't ignore them. Everyone will have something that adds value and could help shape your arguments. And it's important to stay focused, especially in complex personal injury cases. When analyzing your case, ask yourself, what are the pros and cons of my liability case? How strong is my client's damages? Do I have the right economist? Will my surgeon appear at trial? Make a list of your strengths and weaknesses. Don't ignore the weaknesses and prepare for rebuttals and pushback. And ask yourself, has anything in the law changed recently that could affect my case? In March of 2023, Florida shortened the statute of limitations from 4 years to 2 years for general negligence cases, such as auto, premises liability, slip and falls, and other cases. Take a look at 95.114 A through G. Florida also changed the negligence standard in these cases from pure comparative to a modified comparative standard. Now, if your client is over 50% at fault, she is completely barred from recovering damages from the tortfeasor. So ask yourself, do I have sufficient evidence to prove that my client was less than 51% at fault? What are my risks? The new bad faith law under 86.121 mandates that mere negligence alone does not constitute bad faith in statutory and common law actions. 86.121 creates immunity in bad faith actions where the insurance carrier tenders the lesser of either the policy limits or the amount demanded by the claimant within a 90-day period after receiving actual notice of a claim that is accompanied with evidence to support the amount at issue. In cases where you have multiple claimants in a single bad faith action, the law allows the insurer to pay the total amount of the policy limits through an interpleader action at the outset. This will work to limit the insurer's bad faith liability and make the claimants compete against each other for a share of the money. Finally, 86.121 provides separate court proceedings to divide payouts between policyholders and third parties, such as passengers in an automobile accident. The carrier will not have to pay third parties any amount of money above and beyond the policy limit. Be prepared to talk about these issues at mediation, as they will be raised by the other side. If you represent a claimant in an automobile accident, slip and fall, or other premise liability case, keep in mind that letters of protection are now discoverable. Before March of 2023, we could board medicals that were paid and those that were outstanding. Under 768.0427, we can only board past medicals that were actually paid regardless of the source of payment. Read through the new statute and become familiar with what is admissible and recoverable for past and future medicals. What does it mean when a bill is paid? Does it matter who pays it? The statute makes distinctions and draws attention to medical bills that are paid by health insurance providers, workers' compensation insurance carriers, auto carriers under PIP benefits, and medical litigation financing companies that purchase plaintiffs' outstanding accounts from a health provider. Evidence offered to prove the amount necessary to satisfy unpaid charges will now be limited to the amount the claimant is obligated to pay should the claimant have health coverage other than Medicare or Medicaid. What this means is that if the claimant has other insurance and is obligated to pay a certain dollar amount, that will be the amount that can be boarded. Another twist is where a claimant has health insurance and receives treatment under a letter of protection. There, the claimant will only be able to board the amount of his or her health insurance coverage and what would have been paid to the medical provider had the insurance company paid it. If the claimant does not have healthcare coverage or maintains healthcare through Medicare or Medicaid, evidence offered at trial will be limited to 120% of the Medicare reimbursement rate in effect on the date of the incurred treatment, or 170% of the applicable state Medicaid rate. As you can see, these changes create a power imbalance for plaintiffs at mediation, making it more difficult for them to resolve their cases. It'll be interesting to see the development of case law as these cases move forward through the judicial system. Another aspect of sound case analysis is knowing the facts and issues in your particular case. Evaluate the risks and rewards associated with settling or proceeding to trial. And ask yourself, by mediating, will I achieve getting full value from my client's damages? Will I reveal my strategies and techniques? If you and your client decide to walk away, how expensive will it be for you to try your case? We will discuss negotiation strategies, which will help you decide whether to walk away and try your case. I also think it's a good idea to provide your mediator with a brief or summary that is concise and to the point. This gives the mediator insight into the level of the conflict, power dynamics, and the emotional state of the parties. Always contact the mediator beforehand to confirm if he or she is in need of additional documentation, such as deposition transcripts or pleadings or investigation reports. I find summaries that provide a concise set of facts and tables or charts for damages to be very helpful in understanding a PI case. I also find great value in going through jury verdicts and settlements in similar cases. While no two cases are alike, there may be similarities in experts that are used, surgeries that are performed, or economic and special damages that might bring context to your argument. I would also recommend bringing a settlement statement or spreadsheet to run calculations as offers and counteroffers are made. The other recommendations on this slide should also be followed to reduce stress and keep you focused. Next, we'll discuss presenting at mediation. Preparing a persuasive yet realistic view of your case is important. In a personal injury case, it may seem unrealistic to ask for 7 figures for a broken arm or an arm fracture case. However, if the facts and evidence support it, show opposing counsel and the mediator why you think it's worth that much. Otherwise, making unrealistic demands can weaken your credibility and might inflame emotions. There's a high probability that you will not resolve your case in mediation if you take this approach. So I think it's best to lay out the most important facts, address liability objectively, discuss actual numbers in your medical bills, liens that are outstanding, and other aspects of the case. Review the current case law and changes in the law and how it affects you. Look for silver linings within those laws to see how you can benefit from them. But talk about your client's needs. So, for example, their needs for a surgery, rehabilitation, need for mental health care, to wash their clothes. I mean, all of these things, all of these needs are important because these are the things that are affecting your client. You can also use future pain and suffering to add value to your case, but be reasonable and realistic. Now, some other ways that you can bolster your arguments include Having your accident reconstruction expert prepare a video or appear live at mediation explaining the dynamic of an accident to establish liability. Or prepare and show a day in the life video to the other side and the mediator to bring context to the damages and how the accident has changed your client's life. You can also highlight video deposition clips of treating physicians, surgeons, or therapists that explain past medical care and treatment, as well as reasonable and medically necessary future treatments. These ideas might cost extra, but it may be worth it, especially if you have a severe injury case or wrongful death matter. Active listening is critical and essential. Stay focused and hear what is said by the other side. Be respectful and responsive no matter how absurd their argument or demands may be. As a mediator, I find the best lawyers are the ones that ask lots of questions, probe for answers on offers, and show interest in trying to understand the basis of an offer or counteroffer. This approach also allows for the reframing of issues that may bolster your case and minimize its weakness. Negotiation strategies. Power plays an important role in negotiations and mediation. Recognize this dynamic as you negotiate your case to avoid finding yourself at a disadvantage. Anticipate power moves by your opposing counsel, such as the filing of motions to strike witnesses, motions for summary judgment, motions in limine, proposals for settlement, or demands for judgment, or any other kind of motion that a party may file. These motions tend to be filed days or the night before mediation, which puts everyone at odds with each other. These power moves are designed to weaken your arguments and create leverage for your opponent. It's no secret. However, keep a positive mindset, remain confident, and be persistent. Don't be too concerned about facing opponents with vast resources or extensive experience at trial. Focus on the facts and merits of your case and create leverage points before mediation. I can recall many cases that I've handled where low offers were made at mediation, but I was able to achieve a high verdict at trial. I'm not saying not to give mediation a try, but know that you have options. But give mediation your best shot. Have a plan and move forward with your case. Create a framework that helps you stay focused on what is important to you and your client. I think that understanding your client's goals and interests are critical. Their needs are quintessential. Understanding the power between the parties is also very important. Know whether the other side can really try their case. Do they have the necessary evidence to tip the balance in their favor? Do they have substantial financial resources? These are simple things to keep in mind as you move forward in your case. Create a framework that helps you stay focused on what is important to you and your client. Identify your client's walkaway number or reservation point. Know what you will do if you walk away. What is your best alternative to a negotiated agreement? What is your BATNA? Will you try your case? Will you take more depositions? Will you file more motions? Whatever you do, give mediation a chance, though, and use it as a tool to test potential ranges for settlement. Try and develop a range of numbers that could meet your client's needs and close the deal that day if possible. That range is also known as the Zone of Potential Agreement, or ZOPA. Other strategies include trading things of lesser value first. For example, your client may narrow the years of future lost wages, meaning reducing the amount of their claim, or reduce the number of years for pain and suffering in exchange for something of greater value. As you may notice, smart trade-offs are important. Incorporate these trade-offs in your initial offer to give you items to negotiate. However, anchor your first offer at a high but realistic number. This will give you room to negotiate. Offer multiple things in your first offer to then negotiate items. If you get stuck with a counteroffer, consider making a bet. For example, if you're a plaintiff's counsel in a case, you can propose. If you, Mrs. Defense Counsel, win on your summary judgment motion, I will accept your highest offer. If I, as the plaintiff attorney, win, you accept my lowest offer. As you can see, you can design this strategy to entice the other party to accept your bet. Otherwise, your opponent might simply opt out and go to trial. Again, knowing your BATNA, or best alternative to a negotiated agreement, is essential. In other words, know when to walk away, your reservation point, and go to trial, your BATNA. Know if you need to file an appeal or take legal action. If their case is in pre-suit, then file your lawsuit. All of these things help you improve your leverage if you need to sit down again at the mediation table. However, consider the cost of going to trial, paying for expert fees, deposition transcript costs, and time spent pursuing your claim to reach its maximum value. It is also critical to know your zone of potential agreement, or ZOPA. In the next example, I will show you how to formulate your BATNA and your ZOPA. However, try to figure out your opponent's BATNA and ZOPA to ensure that you're close to your target number. To put this all into perspective, you represent a young woman who was involved in an accident. It wasn't her fault, so liability is not an issue for you. In this case, her target is $295,000. Her walkaway or reservation point is anything under $225,000. At $225,000, the plaintiff will meet her needs, but anything below that will be unacceptable. Her option at that point would be to trigger her BATNA either by walking away and filing a case, filing motions, or mediating again down the road. In this example, her ZOPA, or range of negotiation, is from $225 to $395. It's very important that you anticipate your opposing counsel's reservation point, BATNA, and ZOPA to use this strategy effectively. I will discuss that in the next slide. But as you can see, having a plan and a strategy will help you make sound decisions as you negotiate and mediate your case. When you look at the negotiation from each side's perspective, each side's BATNA and ZOPAs begin to appear. Expanding on the previous example, you now know, or you've known, that the defendant has a $500,000 insurance policy. As you negotiate and track each offer and counteroffer, you realize that the defendants may have a $230,000 reservation point. You've been making progress by trading items of lesser values, such as reducing the number of years in your future pain and suffering from 30 years to 25 years. And you've conceded that your client could live without having full invasive surgery. Instead, she's willing to try epidural shots for her continuous pain and PRP shots for her arm. But now the picture is becoming clearer. You now see a zone of potential agreement, or ZOPA, where the defendant's highest offer of $230,000 overlaps with your reservation point of $225,000. That $5,000 overlap is the ZOPA for the parties. Again, it is essential to try and figure out your opponent's ZOPA to know if you're in the right ballpark. In this example, the parties' offers do not overlap, and there is no ZOPA. The defendant's reservation point is $125,000, which is well below the plaintiff's reservation point of $225,000. The parties here can either continue with mediation and attempt to narrow the distance between their offers, or choose to trigger their BATNAs and walk away. I find spreadsheets help me stay on task with my negotiation objectives. This sheet will help me focus on the numbers, such as targets and reservation points. The advantage of the chart is being able to see movements by the parties and their offers and counteroffers, and whether making trade-offs is having an impact in the negotiation. You can also match percentages to each move and know whether offers are significant or minimal. Lastly, the sheet allows you to know when a common or mutual ZOPA is present. Knowing this may help you close the deal at mediation. Now, you can also use this sheet before going to mediation to predict potential moves and know how to best respond to those moves when they appear. Again, be careful not to get caught up in the numbers and allow yourself to focus on the conversations. Being prepared and having a strategy will improve your negotiation power. Here are some additional tips that may help you. As part of your preparation and planning, make a list of your client's needs and rank them from 1 to 10. Package your initial offer with as many items as you can and negotiate the lower ranked items first. Negotiating this way allows you to give concessions and show movement. It allows you to explore your opponent's ZOPA and BATNA. As the negotiation becomes more challenging, bring out your top needs. Understand your opponent and what is influencing their decision. Ask, is a party missing at the table that may have more authority? Look for common interests and needs between you and your opposing side. After all, they're at mediation hoping to close their case. Ask yourself, what is holding them back? But as always, be respectful to everyone at the table. You should focus on knowing the other party's BATNA, ZOPA, and reservation point, which will help you reach your target number. Avoid concessions without receiving something in return. Label your concessions and keep track of them. When a counteroffer is unacceptable, stay silent and think about it. There's no need to rush to answer immediately to a counteroffer. Contingent concessions are also very important tools. Consider accepting a demand if the other party meets a condition. For example, the plaintiff in a case may say she's willing to accept a structured settlement rather than a lump sum only if the defense increases the total payout to $250,000. Or the plaintiff may reduce her demand by $40,000 contingent upon the defendant agreeing to cover all future medical treatments related to the accident over a 5-year period of time. So the benefits of contingent concessions are many and show the parties are flexible, willing to share risks, and desire to build trust. They also show that they are creative in looking for ways to overcome a potential impasse. Building trust with others is very important. In my experience, the majority of cases that settle do so because the parties have come to trust each other on some key issue. The plaintiff trusts and verifies what the defense is arguing, and the defense trusts the plaintiff's representations of the client's needs. I recommend sharing information in an incremental fashion to avoid laying out all of your arguments and all of your trade-offs in your opening statements. Do not share your bottom line number or reservation point unless your position, legal position, or BATNA are so weak that you have no other choice. As I mentioned before, make multiple offers simultaneously to create value and expand your power. You can offer a lump sum to settle the case at $395,000, for example, offer to accept a structured settlement for $300,000 over a 5-year period of time, propose a hybrid offer with contingencies such as a lump sum payment of $325,000 combined with an agreement that the defendants will pay for all related medical treatments for the next 10 years. You can also add that the defendant will pay an additional $50,000 for significant medical complications directly related to the injury over the next 5 years. So these are just 3 examples of how creative you can be with your negotiations. Weakness is when your opponent's BATNA is stronger. It may seem obvious, but don't reveal your weaknesses. You may be the only one in the room perceiving a weakness. In personal injury cases, severe injured clients often are disabled and can't earn a living. If the claimant is the head of her household, she may not be able to wait a year or 2 for a case to settle. Clients in these cases need money immediately and may perceive themselves as being weak. Consider balancing your power by exploring options for your client to receive Social Security disability benefits, SSD. Now, while you may not want to do this yourself, you might want to refer this to someone who specializes in this. The idea is to give your client ideas and motivate them to think outside the box. You may suggest, for example, that they explore getting loans from family members or friends. And if you represent a defendant, explore the tortfeasor's financial status. Ask if the plaintiff is able to achieve a high verdict above policy limits. Will that bankrupt him? Having a policy limit case may create leverage and power over the plaintiff, especially if there's no basis for a bad faith claim. Consider these and other factors as you evaluate your case. What may initially appear as a weakness might be a strength. Mistakes are bound to happen, so don't be too concerned if they do. However, if you prepare correctly, you can avoid some common mistakes. One listed here is coming in with an aggressive first offer in a weak case. I think that is a non-starter. The second most common mistake is the one where parties talk too much and miss the opportunity to hear the other side. Mediation is an important tool as it gives each side an opportunity to see and hear the other side's argument and analyze their demeanor and behavior. As part of your self-awareness strategy, challenge your assumptions about the other party. Don't take anything for granted. Also, don't assume that you know all of the arguments and positions that they may have. Now we'll move on to caucusing and managing emotions. Caucusing refers to a private meeting during mediation, usually between the mediator and one of the parties, outside the presence of the other party. I think caucusing is very effective because it allows the mediator and the parties to maintain confidentiality, minimize the effect of emotions associated with offers and counteroffers, and serves as a safe space for clients. However, caucusing can be lengthy, especially in complex and multi-party cases. In some cases, such as class action matters, the mediator must meet with multiple parties and attempt to narrow difficult issues, which takes a lot of time. These types of mediations can last all day, several days, sometimes even weeks. It is critical to acknowledge and know how to handle strong feelings or emotions that come up during mediation. It's not unusual for an accident victim to become emotional while sitting at mediation and listening to the facts of her case. This happens a lot. Attorneys also become frustrated, especially over low offers or when parties are stuck on the numbers. Emotions can also get stirred when opposing counsel makes a remark about your case in front of your client. But when these things happen, pause, ask for a break, regroup, and if you're with a client that is upset about something, use comforting words to minimize the emotional effect of that. Then come back into the room, refocus, and reframe the conversation. For example, with low offers, look at them as opportunities to trade less valuable items for more critical needs. Following these steps will reduce the influence of emotions and help you remain focused. Next are important documents for you to take into mediation. Know the elements of a mediation agreement. Remember that the mediation agreement is not the full settlement agreement or release. It is a summary of each party's understanding of the agreement that is reached. In many, if not all cases, the parties themselves will work on the agreement. One party may draft the agreement, and it is passed along to the other party for revisions or tweaking. Take a sample mediation agreement with you and be familiar on how it works. Use it as you prepare your mediation agreement. It is also important to have an idea how a settlement offer will affect your client. I like taking spreadsheets with me to mediation to run numbers and fine-tune my ZOPA. Here, I have a settlement statement with numbers attached. Remember, don't get too focused on the settlement statement as it can distract you from listening to offers, speaking to the mediator, and listening to your client. If necessary, invite a law clerk, paralegal, or someone to help you keep track of the spreadsheet. I also recommend you take a sample release with you that can be proposed or used to negotiate terms. Having a sample release will serve as a checklist or reminder of important issues or needs. Not every release needs to have a confidentiality clause. Confidentiality clauses, admission of liability language, and indemnification terms are potential trade-off items that you can exchange for other things such as earning interest on settlement funds that are delayed or disputed for some reason. Complex agreements can be exhausting and perhaps too much for a small case, so be careful with agreements or releases that impose additional obligations on your client beyond the four corners of the case. We often see this in personal injury cases when one party creates a very long list of responsibilities for the other party. The obligations become so numerous that you begin to question who brought suit against who. Be prepared to address these issues at mediation before a deal is made. Otherwise, your client could face a breach of contract action or be compelled to meet those obligations by a judge. Once a case is settled, the mediator will prepare and submit a report advising the court of the results of the mediation. Next, the parties will agree to dismiss their action. Make sure that the dismissal language is consistent with the terms of the settlement agreement. Be sure to include the dismissal is with prejudice, meaning that it cannot be refiled against any of the named parties, and that each party shall bear their own costs and attorney's fees. In all of my cases, I like adding the language that the court shall maintain jurisdiction to enforce the settlement agreement. It is customary to file a proposed order for the court to sign, so make sure that it's comprehensive. But that aside, the parties will agree that one attorney will file the motion and follow up with the court. Lastly, the parties will receive an order of dismissal of the action after the stipulation is filed. Be sure to confirm that the order is consistent with the joint stipulation of dismissal. So remember to be prepared as if mediation were a trial on the issues. However, be realistic with your offers and counteroffers. Remember that you'll have to give up something to get something. Make sure to remain focused on your client's goals and needs. Avoid getting stuck in legal positions. And know when to walk away because not every case gets settled. When in caucus, communicate, ask questions, and summarize what you're hearing to avoid confusion. This also helps to avoid emotional flare-ups. Know yourself and know what triggers your emotions. Have a strategy to minimize these feelings. Pause before you formulate a counteroffer. Ask for a break, gather your thoughts, regroup, reframe, and come back. Be persistent, but be respectful, and remain open-minded throughout the process. And again, don't forget to take the following documents with you: a settlement statement, a sample release, sample mediated settlement agreement, and perhaps someone from your office to help you keep track of these. I hope you found this presentation to be useful and that it helps you close your cases moving forward. I've included some articles and other materials to help you understand the importance of trust, self-awareness, and awareness of others. You'll have copies of the latest statutes that I referred to in the presentation and some sample forms. I welcome any comments, recommendations, or observations regarding this presentation and the mediation process. I wish you all great success as you venture forward in your new firms or in your practice of law. You can email me or call me if you have any questions or need any additional forms. Thank you for attending this program, and good luck.